Hello, and I welcome you all to my YouTube channel Logical Upgradation. First thing first, pardon me for my absence in your YouTube and digital space for quite a time. I was busy with my personal and professional obligation. Nevertheless, today I am going to discuss with you a very important development that has taken place in the Supreme Court yesterday with respect to one act, one statute, that is Prevention of Money Laundering Act 2002. Supreme Court has upheld the constitutional validity of the Prevention of Money Laundering Act 2002. This act confers various powers to the agency called Enforcement Directorate with respect to inquiry, with respect to investigation, seizure and attachment of property. However, Supreme Court held that the amendment in the enactment in the year 2019 to PMLA, that is Prevention of Money Laundering Act, as a money bill has to be considered, has to be dealt by a larger bench of 7 judges bench of Supreme Court. The said matter is pending before the same bench. Now, let me throw some light. Let me take you to the brief background of Prevention of Money Laundering Act. What are these objectives and what purpose the said legislation wants to achieve it. First thing first, the said legislation of PMLA, Prevention of Money Laundering Act, was enacted by Parliament in the year 2002 by NDA first government, National Democratic Alliance, first led by late Sri Atal Bihari Vajpayee. So the very purpose and object of the PMLA 2002 was in accordance with India's commitment and obligation to tackle the international problem of money laundering. The present legislation gives a lot of power with respect to search, with respect to seizure, inquiry and investigation that are very different and distinct. Procedure is very different and distinct laid down in the Criminal Procedure Code 1973. The judgment was pronounced by 3 judges bench of the Supreme Court, including Justice A.M. Khanwilkar, Justice Maheshwari, Justice Ravi Kumar. On a bunch of petitions, various aspects were challenged. The petitioner sought the constitutional validity of the said legislation by stressing upon the principal point. The principal point of the petitioner is that, for example, the first point was that the reverse burden of proof on the accused to prove his innocence. I am going to discuss in detail on this point in the later part of my video. The second aspect, the second point to ponder was that the stringent and strict provision with respect to the bail. And the third was that the absence, according to the petitioner, the absence of the fair, reasonable procedure with respect to commencement of trial and the summoning of the accused, which has a direct consequences and interlinked with Article 21 of the Constitution, which speaks and provides for right to life and personal liberty. The petitioner further pointed out that the said agency, that is Enforcement Directorate, has carried near about 1500 to 1700 raids since 2011, and out of those 1500 to 1700 raid, the said agency, Enforcement Directorate ED, secured only 9 conviction out of 15 to 1700 raid. So it has a very dire and it has a very alarming ratio between raids conducted and convictions secured by the agency. Further, the petitioner also contended before Supreme Court that the staff, the manpower in the PMLA appellate tribunal is very less, thereby causing great hardship and obstacle and difficulty while securing the ends of remedy and justice and with respect to seizure of property. So these are very principal points raised by the petitioner while challenging the constitutional validity of the present legislation, that is PMLA 2002. To this, Government of India, central government came down heavily in defense of the PMLA 2002, PMLA Act of 2002, said that the Prevention of Money Laundering Act is a special act and it has its own special and exclusive procedure. Further, government says that the money laundering is a serious threat to country's economic health and hence needs a stringent and strict statute to deal with it. Supreme Court the bench upheld that the constitutional validity of Section 5, Section 8, Subclause 4, Section 15, 17 and 19, which provides for seizure, inquiry, investigation and attachment of property by Enforcement Directorate is constitutionally valid. Further, it is very pertinent and important to note that Supreme Court speaks also about Section 24 in the said Act. Section 24 provides that the burden of proof is on the accused person to prove his innocence, which is in direct contravention to the established criminal jurisprudence. Our established criminal jurisprudence speaks and provides that every accused is innocent until proven guilty. So the burden of proof is on the prosecution, that is state, to prove the guilt of the accused. On the contrary, Section 24 says that the obligation is on the accused, the burden is on the accused to prove his innocence. Further, Supreme Court says that the complaint report is not equated with the term FIR in the CRPC. So hence, once it is not in equal terms with an FIR in CRPC, it is not mandatory or it is not an obligation on part of the investigating agency to provide a complaint copy to the accused. It is enough if the Enforcement Directorate directly discloses at the time of arrest the grounds of arrest to the accused. The further, Supreme Court says that the ED officials are not police personnel, are not police officers under the said Act, and hence the statement made by accused person to officer under Section 50 is not hit by Article 20 Subclause 3 of the Indian Constitution. Article 20 Subclause 3 provides for protection to person against self-incrimination. So basically it means that no one can be compelled to give statement or evidence against himself so that he can incriminate himself in any alleged offence or crime. Further, Supreme Court said that it is in this regard the court pointed out that Section 50 is in nature of inquiring and not investigation. So apart from addressing the challenges pointed out by petitioner, Supreme Court has also directed the Union Government to fill the vacancies in the PMLA Appellate Tribunal as soon as possible, so that there will not be any hardship or obstruction to the concerned person. So this is an issue in development. It is receiving a lot of comments across political circles. If you like my attempt and effort to bring you the legal and factual aspects, please ponder subscribing my channel. This is it for the day. Thank you.